My name is Thomas Drake. I'm a decorated veteran of the United States Navy and Air Force. I served my country in uniform, and then I served it again as a senior executive at the National Security Agency, one of the most secretive and powerful intelligence organizations on earth. I believed in public service. I believed in the oath I took. And I believed that when I saw something deeply wrong, it was my duty to say so. What did I see happen after 9/11? Under the secret authorization of President Bush, the NSA made a deliberate, willful choice to bypass the Constitution. A top-secret program known at the time as Stellar Wind was quietly launched to conduct warrantless domestic surveillance on the American people. Phone calls, emails, metadata, and more. Millions of people surveilled without a warrant, without probable cause, without any court order. The Fourth Amendment, the foundation of your right to be free from unreasonable government searches and seizures, was simply set aside by executive order in secret with no accountability. I went through every internal reporting channel available to me as a whistleblower: the internal chain of command, the Office of General Counsel, the Inspector General, Congressional Intelligence Oversight Committees, the Department of Defense Inspector General. I also shared information that NSA possessed intelligence that might very well have prevented the 9/11 attacks. I did everything a loyal, law-abiding government official was supposed to do. Every door the system told me to use, I used it. And then I went to the press with unclassified information. In April of 2010, the Obama Justice Department indicted me on 10 felony counts under the Espionage Act of 1917. 5 of those counts were for willful retention of national defense information. I faced 35 years in a federal prison, not for selling secrets to a foreign power, not for sabotaging American operations, for raising the alarm through all lawful whistleblower channels, and then exercising my First Amendment right as an act of civil disobedience to bring a grievance against my own government with the press about multi-billion-dollar fraud, waste, abuse, and the systematic violation of the Fourth Amendment rights of the American people by the government in secret. That is why the Daniel Ellsberg Press Freedom and Whistleblower Protection Act matters so profoundly to me. Daniel Ellsberg was charged under the same section of the same Espionage Act, Section 793E, that was used against me. He spent the rest of his life fighting for the reform this bill represents: a public interest defense, a narrowed scope, and a law that can no longer be turned on the very people protecting democracy. That's why this June, Espionage Act Awareness Month, I'm calling attention to this bill that offers a real path forward and introduced by Representative Rashida Tlaib, and named for the legendary Pentagon Papers whistleblower who spent the rest of his life fighting for this reform. This bill would do 3 critical things: limit the Espionage Act to those with an actual legal obligation to protect classified information so it can never again be wielded against government employees, journalists, or the general public as a weapon against First Amendment protected dissent and truth-telling. Create an affirmative public interest defense for whistleblowers, and require the government to prove a defendant acted with specific intent to harm the United States or benefit a foreign power.